If we could go back maybe to Mr. Chisholm at this point and ask you to maybe lead us through a little bit about, how this particular situation came to be, and maybe intertwine with that how the bail system works in Milwaukee County, if you don't mind.
Mr. Chair, members of the committee, yes. Let's focus first on the decision to recommend a $1,000 cash bail. That is a decision that on its face, I have already articulated and stated fairly early as this was unfolding that I believe that was inappropriately low given the context of what we knew about the defendant. And let me also make clear, I am saying this not just because it's my ethical obligation to say so, but because it also points to a really important point, and that is that anything I say right now has to be remembered in the context that Mr. Brooks is presumed innocent until the cases are adjudicated. Prosecutors are obligated to say that in any case where a charge has been issued. And it speaks to the issue of bail as well, and that is that the state ultimately bears the obligation to prove every case with evidence that supports a finding of proof beyond a reasonable doubt. The state's main power, as it were, is to issue a charge. We do not ultimately decide the outcome of that charge. It either goes to a jury trial, it goes to a court. We make arguments, we present evidence, but our ultimate power is to make a charging decision. In this particular case, the statement we released early on was to indicate that Mr. Brooks had already been arrested and charged with a serious weapons-related offense. On that case, $10,000 cash bail was set. Now the context of the enormous challenges that we are facing in relation to the pandemic come into play, because what occurred is that this defendant was held on bail and that trial dates were set. He had a trial date set that we could not provide a court trial for him or a jury trial for him on that date, but it's not because we weren't doing anything else. I think the courts can speak to what else was going on that day. But under the law, there is a requirement that a person's custody status be reviewed if you can't provide them with a speedy trial. That's what occurred. The bail was reduced in that case. Time later, Mr. Brooks is arrested again, and this time it's for a very serious domestic violence offense. This brings in the Milwaukee DA's office once again, and the decision, which was appropriate to charge Mr. Brooks with a very serious allegation and issue a criminal complaint on it. The context, I can tell you from having examined the circumstances surrounding this decision, is that the ADA, who is has about 2.5 years experience, but is already prosecuting domestic violence felony cases. She's one of our 2 dedicated domestic violence felony cases, has already in 2.5 years done over 20 jury trials. That week, she was actually in the middle of a jury trial, a 2.5-day jury trial, in addition to having almost 24 felony level cases to review. This case was one of those cases she was reviewing in that context. And we have established a risk assessment system in Milwaukee County, which is really important to understand. When I first ran in 2007, I made a commitment to the community that I would do everything in my power to try to identify people by risk. And those people that pose less of a risk, even though you can never guarantee that they are not going to do something more serious. But with all the information we had, if we could identify people that were drug addicted, mentally ill, lower level offenses, we wanted to do something different with them so that we would have the resources to focus on violent people that hurt other people. That was the goal. That is the system that we've put in place. And that system actually was operating and should have been followed. It should have been followed. There was a public safety assessment that was done that characterized this situation as a high-risk situation. Our default position in this case, because of the laws in Wisconsin, is that we recommend higher amounts of cash. That's not what the law says, by the way, the law says that cash is only intended to bring the person back to court, and non-monetary conditions can be considered factoring in the dangerousness and the risk to the victim and other factors like that. Nonetheless, higher cash bail should have been recommended in this case. In talking to the ADA, what she indicated is that she did not have access to that public safety assessment. It's not because it wasn't done, it just hadn't been uploaded into our case management system. Given the volume of cases she was dealing with, given her jury trial that she was working on, she simply charged the case. She looked at the previous bail, saw that it was $500, and she doubled it. That's it. That's a mistake. That's human error. And it just set in motion a chain of events that resulted in a tragedy. And again, not trying to lessen our responsibility for that, but that's it. And there's a lot more information we have to talk about going forward, and I'm going to be as transparent and accountable for that. But in essence, that's what you had. You had a young ADA trying to do the very best she could under really difficult circumstances, and she made a mistake.